So with no further ado, we'll call to order the Old Bridge, New Jersey Planning Board meeting for tonight, August 3rd, 2021. Okay, if we could rise and salute the flag, please. Pledge of allegiance
to the flag of the United States of America, and to the republic which stands one nation, under God, indivisible, with liberty and justice for all.
Good evening, board members. Before we open the meeting to the public, I have a small announcement. For tonight's meeting, we have Danny Holihan acting as the board secretary while Dawn is away. Danny has been the administrative assistant with the engineering department for more than a year. Most of you have seen him when you have stopped by our office. So I truly appreciate Danny for taking this additional responsibility and helping me for tonight's meeting. Danny, all yours.
Okay, thank you, Danny.
Thank you, guys. Adequate notice of this meeting of the Old Bridge Township Planning Board has been provided in accordance with the Open Public Meetings Act at least 48 hours prior to the commencement of this meeting by prominently posting in the municipal complex an announcement giving the time, date, location, and agenda of this meeting, mailing such announcement to the Home News Tribune, and filing such copy of announcement with the municipal clerk. Mr. De Palma?
Here.
Mr. Renna?
Here.
Mr. Lauer?
Here.
Mr. Mamakis?
Here.
Ms. Cannon? Ms. Cannon?
She's on mute.
Okay, we'll come back. Mr. Schmidt?
Here.
Mr. Lenning?
Here.
Mr. Pink? I don't think he's here. Chairman Marucci?
Here.
Mr. Petty?
Yes, here.
Mr. Garcia?
Here.
Mr. Sardillo?
Here.
And Ms. Savant?
Here.
And I see Mrs. Cannon is off mute.
Yeah,
Yep.
here.
I got her. Thank you.
Okay, thank you. Okay, we had a slight change in the agenda with Brightpoint looking for a continuance. So what we'll do is we'll start off with the minutes from July 6, 2021, and then we'll move into to their continuance before moving to the completeness waiver. So first, I'd like to have if somebody could have a motion for the minutes of July 6, 2021.
I'll move it.
Okay, moved by Cannon, and a second
I'll second it.
by Mr. De Palma.
Mr. De Palma?
Here.
I need a-
Off mute.
Yes.
Okay, thank you.
Mr. Renna?
Yes.
Mr. Lauer?
Yes.
Mr. Mamakis?
Yes.
Ms. Cannon?
Yes.
Mr. Schmidt?
Yes.
Mr. Lenning?
Yes.
And Chairman Marucci?
Yes,
Yes, there we go.
yes,
Mr. Pink has joined us too.
yes, Mr. Pink is in now.
Should I include him in this roll call?
Yes, but he didn't answer because he wasn't on.
Okay. Should I include him in the minutes?
Okay, so Mr. Pink, you're here?
Yes.
Okay, thank you. Okay, so we will move on to the continuance for Brightpoint Housing, which is 01-2021P, preliminary and final site plan with C-value. So is the applicant available?
Mr. Chairman, both Ms. Savant and myself had spoke to the applicant's attorney, Amanda Curley, and they, based on some recent new activity from some of the adjacent property owners who were potentially objectors to the application, and some questions relating to the public notice that was provided. I just want to be clear that the notice that they did provide was a legally sufficient notice. However, it did have some incorrect addresses on the 200-foot property owner list. It wasn't up to date, but they're allowed to utilize that. So it was legally sufficient, but they want to make sure that they're all, everything's up and up. Plus, they wanted an opportunity to reach out to the neighbors and see if they can address some of their concerns prior to presenting before the board. So they asked, based on those reasons, they asked if they could carry it for one more board meeting to have an opportunity to renotice. So the application will be renoticed. So there's not an issue with that, and have an opportunity to meet with those adjacent property owners to see if they can what those concerns are and if it's something they can address.
Okay, do we have a date in mind?
September 7th. We have other things on the agenda, but I think September 7th is the next date for the meeting.
So September 7th is sufficient, there's enough room?
I believe so. Ms. Curley was looking to start working and reaching out to the neighbors as of this afternoon. So I think they would be like to be placed onto the 7th, the September meeting. And they will, as I said, they will be renoticing so that we don't have to make an announcement and have a date certain. So if something does change, they need to change it to another date, they could work with our planning department and notice for the appropriate date.
Okay, very good. Okay, do I have a motion? Oh, I'm sorry.
Dean, can I just ask a question?
Certainly.
I just wonder, do we have any deadline for asking for a continuance? I mean, could they do it up to 5 minutes before we start the meeting? I just wonder if we have any kind of restriction as to when they can ask for a continuance.
Ms. Cannon, there's nothing that I'm aware of in our rules or regulations for the board. I mean, technically, they could have come to the meeting, been prepared to proceed, and then bumped into some people, objectors, and asked for continuance because of something that might have happened just as the meeting started or during a meeting, during another public hearing. So there's no set rule of a deadline when it has to be requested. In this case, they were prepared to appear this evening. It wasn't until actually some of the issues that were being raised by the neighboring property owners that they decided to adjourn it. It wasn't really, it was more of reactionary to that issue, not something that they were anticipating and then just waited to the last minute to make the request.
Okay.
Okay. I just spent most of the afternoon going through all the memos and stuff. And
I did the same thing. I was doing the same thing, and I actually had just finished when I got the call from Ms. Curley, so I understand.
Well, you'll be prepared for next month.
Yes.
I bet I'll,
And
okay.
just for the benefit of the board members, Joe and I found out about the adjournment only around 2:15. At 2:20, I sent out an email informing everything would be adjourned. So that's when we found out too.
Okay.
Okay, any other questions from any of the board members or professionals? And if not, I'll ask Mr. Pink. No? Okay.
No.
Okay, I'll ask for a motion. Do I have a motion?
The latter continuance.
I'll make the motion.
I'll
Okay,
second
Mr. Lauer, and a second.
I'll second it.
Second by Mr. Pink.
Mr. De Palma,
Yes.
Mr. Renna,
Yes.
Mr. Lauer,
Yes.
Mr. Mamakis,
Yes.
Ms. Cannon,
Yes.
Mr. Schmidt,
Yes.
Mr. Lenning,
Yes.
Mr. Pink,
Yes.
Karen Marucci.
Yes. Okay, thank you, everybody. And now we will move on to the completeness waiver, which is 80-2020P. Chris Wisniewski, 24 South Street, and it's, again, a completeness waiver request. Is the applicant available?
Good evening, Mr. Chairman, members of the board. My name is Donald B. Fraser Jr. I'm a member of the law firm of Parada, Fraser, and Forrester of Clark, New Jersey. I represent 24 South Street Properties, LLC, and its principal, who is in fact Chris Wisnowski. I do note for the record, Mr. Wisnowski is observing tonight's proceedings. He's the black box that says Chris, but I don't anticipate presenting him or presenting any testimony this evening.
Okay, fair enough. So no testimony whatsoever, just a request for.
Waiver.
That's correct, Your Honor. Not Your Honor, excuse me, Mr. Chairman.
No.
No, that's right. I don't know if that's a promotion or a demotion, Mr. Chairman. But that is in fact correct. I had spoken with Ms. Borbely, I guess it was, I don't know, two and a half weeks ago when I was told that we were on for this evening. I confess, my procedure, I'm the attorney for the Garwood Planning Board. Our procedure is a little bit different. So this was new to me that I'd be coming before the board for these completeness waivers. And I inquired whether I should bring a witness or be prepared to present testimony this evening. And I was advised no, that I shouldn't be doing that I shouldn't notice the hearing at all. So I did not, without noticing, and I don't think I can present testimony. But I'm here to address any concerns or questions that the board has with regard to the waiver request, which I had submitted by letter of July 6, 2021. I did speak with Ms. Sawant, I guess it was yesterday, concerning this. I mean, my request is set forth in my application.
Okay, yeah, and I've read through the letter and I don't see anything that's glaring. Ms. Sawant, do we have any objections or any points we'd like to make?
Sure. So the applicant is requesting 6 waivers from a few of them are technical in nature. I am recommending, I'm sure the board has received my memo from this afternoon. I recommend that the applicant submit a survey because that is critical. So I recommend the board not waive the survey. There were 2 other items on the list out of the 6 that I wasn't sure because I didn't have adequate information. And I just want to give the board members a little overview of what's going on. I'm going to share my screen with the aerial on for you to look at. Lot 4, this is Jamie Court. This is lot 4, the property in question, and lot 137.11, which is the second property in question. What the applicant is requesting is a lot line adjustment, which means that they want to remove this lot line, which is the rear property line of lot 4, and extend the lot line here, which I'm showing with the cursor, towards the end. So in as a final product, what happens is this lot, which currently contains a home, becomes one lot. The second lot would be this L-shaped lot with a deep backyard, but this was the second lot that will be created from the lot subdivision. Now, as you can see on the aerial, this portion of the property, so the rear portion of 137, lot 137.11, which is going to be part of lot 4, is heavily wooded. And the applicant is seeking for a waiver from the tree plan. The applicant is also seeking waiver from any outside agency approvals. Now, as practice and in Old Bridge, because we have properties that have some sort of constraints, I happen to go and check the wetland layer. This website is NJDEP's database. You will notice that the rear side of the property is wet. It has significant wetlands. So now, before the board grants these 2 waivers, because there are wetlands on the property, NJDEP, anything that needs to be done in the rear portion would require DEP approval. And because it's wooded, also raises the concern. So without having adequate information as to what is the purpose of this subdivision, I wasn't able to make any recommendations. So now I request Mr. Fraser to just shed some light on what is the purpose of this subdivision, because typically planning frowns upon such subdivisions where you create odd shaped lots. So can you please explain to the board before the board considers these waivers? And I'm going to share the screen again so that we have a reference to talk.
Okay, yes, I'm happy to. First of all, preliminarily, I think that Ms. Sawant did an excellent job at the beginning of describing what it is we want to do. And with the overhead geo map there, I think it's helpful. Fundamentally, my client who resides on the lot that faces Jamie Court intends to sell the house that faces South Street. As part of that, he would like to enlarge his backyard and not sell the part of the lot facing South Street that is directly behind his house facing Jamie Court. So that is the genesis, if you will, of the application. So if you look at it from Jamie Court, you know, and if you go straight back, what he wants is he wants to put as part of his lot, the part of lot 19010.11, excuse me, lot 137.11, that's right behind him, and then to the left, because there's no other way to do it. And it still leaves a very large lot for the house that faces South Street. These two lots, when this is all said and done, are still going to be two of the largest, if not the largest, lots in this neighborhood. I would respectfully disagree a little bit with your planner that these are going to be some really weird, irregularly shaped lots. The lot that faces South Street, when all is said and done, will still be rectangular in shape. It just won't be as deep as it was. And the L-shaped lot that my client ends up with still complies with the various requirements in terms of frontage, in terms of lot width, and so forth. The only part that maybe is a little bit weird is that the part to the left where it's heavily wooded, and which I now learn may be wetlands designated, will now be part of that lot rather than be part of the lot facing South Street.
Now, Mr. Frazier, I'm sorry, I don't mean to interject, but you said maybe wetlands. Is there an LOI? Has it been determined and delineated that it is in fact wetlands?
Quite frankly, Mr. Marucci, I have no idea until I saw this colored rendering that your planner has just laid on top of this. I had not even thought about the question of whether those woods, which are to the, the farthest away portion of the tract away from South Street, I had not even thought about whether they were wetlands or not. They're woods, and absolutely no development is proposed or contemplated for that area. There are woods today, they're going to be woods tomorrow, they're going to be woods next week, and whether or not there's a wetlands designation for it, I don't think has anything to do with this application, sir.
Okay, and as for the neighbors along Jamie Court and the bend that goes around, the neighbors that are basically back up to that new L shape, has anybody communicated with them?
Actually, the answer to that is yes, Mr. Marucci, because when I was first discussing this application with my client, and it must have been, it was before COVID time, so a year and a half ago maybe, I had the idea, being an amateur engineer and land developer, that maybe it would make sense to give or to sell the portions of this L shape that is behind those lots to the owners of those lots, because it does not really add to the economic utility of my client's parcel. talking really about lots 5, 6, 7, and 8 on Jamie Court. Now, of course, you only could do that if everybody wanted to do it. Because, for example, you couldn't give lot 6 the portion of the land that goes behind lot 6 unless lots 7 and 8 were with the program, because otherwise you'd be orphaning that land.
Yep, agreed.
The short answer is that trying to get lots 5, 6, 7, and 8 all on board with my amateur proposal didn't work.
So were there some yeses and some nos?
I don't think it got quite that far that I would say that there were specific yeses. I wasn't personally in those conversations. I would say that there was some interest, but there was at least one no.
Okay.
And once you had one no, I said to my client, all right, well, forget that. If the people don't want to do it, we can't do it.
Yep.
But I had the same kind of idea.
Okay.
Because it seemed to me if I had lots 5, 6, 7, or 8, and somebody wanted to give me some additional land behind it, whether it was wetlands or not, I'd be like, oh, okay, I have a bigger lot.
Unless it had some tax implications, maybe that's an issue.
I think that there was at least that feeling, albeit the degree to which that would materially impact the value of the land, I personally think is questionable, but what do I know?
Yep. Okay.
Great minds think alike, though, Mr. Marucci.
Yeah. And the nut doesn't fall too far from the tree. Okay,
Chairman-
Ms. Swan, anything?
Yes,
Anything else?
Chairman Marucci, I heard what the applicant's attorney is saying, but at the same time, knowing that there are environmental constraints, even if nothing was to be built, and if the property owner on lot 4 wants to extend and use that, expand the backyard, then it is a problem to me, because just look at the map. The wetlands, and these are not delineated. This is NJDEP's data, which we always rely on until we have a firm LOI. But I don't understand the benefit even to the owner of lot 4 if the wetlands are touching the property line or are within the area. How much of that backyard can they really use, because NJDEP will not, and this is just the wetlands. It is not the wetland buffer. So typically all wetlands have a 50-foot buffer. So I don't believe there is any usable space behind this lot. And that is why having state approval, having DEP look at it is quite essential. And also with the tree removal, I mean, I get it, they're not developing, because that was my primary concern. But to waive off other agency approvals, I wouldn't be so comfortable looking at this map. Handing over a portion of this lot to the neighbors, again, if it is wet, it has constraints. I don't see the benefit of adding those lots.
Gina, excuse me.
So-
If I could
Can you zoom
respond
in
to
a little
that.
bit? Can you just zoom in a little bit further?
Zoom in or zoom?
Yeah, zoom in a little bit closer to the property so we can. All right, yeah, a little bit. Thank you.
It's not full.
Okay.
Yes.
If I could just respond to that for a second. The application does not contemplate anything being done. So I don't know why we're talking about tree removal or impact upon the wetlands. At the present time, these 2 lots are under common ownership. So at the present time, my client could or could not do on the wetlands portion of this the exact same stuff that he could or could not do were the application to be granted. If he's allowed to walk, for example, into those woods next week or next year after the application were granted, he has that same ability today because the 2 lots are under common ownership. As a practical matter, the only thing that we're really talking about that's relevant to this application is the fact that the lot which faces South Street, on which that house is situated, is going to be for lack of a better term, shallower than it is today. Other than that, it's the exact same situation.
Mr.
I
Freire,
would also suggest that while I don't believe there's any reason why there would have to be DEP approval on this, that certainly that could be a condition of approval.
Mr. Fraser, we're just talking about the waiver right now. I'm sure you will have an opportunity to come in front of the board and present your case at the public hearing. Whether the question is there are wetlands, whether you build something or not, the use of those wetlands, the encroachment or walking onto the wetlands, it's all regulated by DEP. The township doesn't authorize any use of that space knowing that there is wetlands. And that is what I'm bringing up in front of the agency, the board. So if you agree to have that as a condition of approval and get NJDEP approval before compliance plans, then that would be something which the board has to decide whether they want to entertain or not. But the rear portion, the proposed rear portion has constraints. The township doesn't have even the ability to allow you to walk or allow you to authorize any use on that rear portion, knowing that there are constraints. And that is that is the issue I'm bringing up.
And I appreciate that, and it's certainly interesting and arguably relevant that that land back there may contain wetlands. But given that the present application does not propose any change of use or indeed any specific use at all of the wetlands designated area, and given that there is no development proposed and that the only thing that we're talking about is the redrawing of a line, I certainly respect your opinion. I respectfully disagree that that should be dispositive here. But if that has to be addressed as a condition of any subdivision, I would suggest to the board that this is something that we can address at the hearing on the subdivision, and it does not need to be a precondition to get on the agenda. And for that reason, I suggest and submit that the waiver is in fact appropriate at this juncture.
Well, if I may just jump in, because I might be just a little bit confused, because I think the confusion here is whether the waiver being requested is a status of any outside approvals that would be required. It's not saying that they are required. It's saying whether or not, if they do trigger, if a soil movement, if a county approval is required, if something is triggered based upon the application, you have to provide us the status of those approvals. So, I mean, I think this is, we're kind of losing, or what's the saying, you're lost in the trees among the forest, because we're not deciding here whether or not DEP approval is required. We're not saying that a wetlands application is required. We're not saying that you need a riparian permit or anything of that sort. This waiver is just saying if those things are required, you have to, based on the application, you have to come to us, because we can't, the board has no jurisdiction as requiring whether or not a DEP approval, a permit is required or not. We can't say you have to go to the DEP. It's a DEP regs that govern whether or not when you have to go before the DEP or the county board or whatever it may be. So I think it really, I just think to ease the board's concerns, I think, this waiver just might not be necessary here, because if the board's concern is saying, if those things are, if we waive this, then if they do get triggered by something in this application, which I don't know if I don't have a full application before me. I just have a few pieces of documents in the map that was before us. But if these are triggered and they end up being required, or you do need a wetlands delineation at some point, and we waive this, then we're kind of letting ourselves off the hook and we don't get it. So I think if we don't waive it, And it's still a requirement saying if you are required to go to the DEP or the county or whatever it may be, you still have to give us that information and provide us that information is connected with the application.
Okay, but I think in response to that, Mr. Sardillo, and I'm not asking the board to somehow bind DEP or anything like that. I think you have to look at this in the context of, I'm looking at the April 30, 2021 letter from the planner saying my application is incomplete for the following reasons. And what I did here was I looked at that letter and I said, okay, I don't want to do the following things now. Waive this for now. Deem me complete. Let me get before the board. If I still have to do something later, I guess I still have to do it. But I don't think there's anything here that should stop me from getting on the agenda.
So, Mr. Sardello and Mr. Fraser, to respond to that, as a practice, because it is part of the application form, typically the applicant puts in some information, will work towards it, will be a condition of approval. They fill in something. In your case, that table was left blank. And that is why we, as a checklist item, we would ask you to do it. It's a practice with all applications. So I cannot have an application form without information in it. And that is why it was listed as an incomplete item.
Okay, and I'm not criticizing that. I'm simply saying that on these facts, this application, what we've provided with this explanation, I respectfully submit, Mr. Chairman, there's enough that we should be on the agenda.
Okay.
And just to response, I based on what Ms. Savant said and what Mr. Fraser said, I don't disagree. I think it just needs to be clear that that I don't think you need a waiver for it to be deemed complete based upon the testimony that was given, and or not testimony, but the representations that has been made so far at this board, is that it will be anything that would be required would be a condition of approval if it is triggered. I think I don't want to put words in your mouth, but I think I heard you say that at one point, Mr. Fraser. So
Yeah,
that
I have no problem with any of that, Mr. Sardillo.
so that
You
would
said it more
in
eloquently.
the
Let's say
application
that.
forms. What's that?
You said it more eloquently. Let's just say that.
But so in a sense, board members, it would be as if he had put that in the application to form. Now that's being filled in here. So it's not that that needs to be a waiver. It's just if that gets addressed or it gets triggered, that will be considered and part of the application, will be presented to the board, and will be a condition of approval if necessary.
So then, Mr. Sardillo, what are we voting on?
Yeah.
Sounds like we're not voting on anything.
Well, we'd be granting, I still believe.
Well, if we're granting waivers, we're granting waivers though.
Right.
Correct?
Well, we still have a number of waivers that they're requesting that would be granted. I still, based on what my understanding, and please correct me if I'm wrong, is that the applicant does not need a waiver from item 26. But it won't not getting a waiver will not bar them from appearing before the board, because they will address that if it is applicable and will be a condition of approval if necessary. So the other waivers, item number 21, 28, 37B, and Vina, correct me if I'm wrong with regard to 52. I think you said you understand now that since there's no development, we might not need that. So it would be all the waivers requested except for 26 and 23, which is the relating to the survey. It would be a motion to grant all those waivers. And it's the understanding that even though we're not granting a waiver from item 26, that's not something that they need to produce at this time. It would be something that will be addressed at the application before the board and will be a condition of any approval if granted.
Okay. Any other questions? Any questions or comments?
Yes, Chairman.
Go ahead.
Mr. Lauer?
Yes. So
the waivers you have on there, if we vote on, the 23 and 26 would be added to that approval. Did I get it right?
It would be a
Yes.
condition of the approval, correct?
Well, those will be out of the granting of the waivers. Any motion this evening would not include items 23 and 26.
Okay, thank you.
Okay, anyone else?
Ms. Savant, as our professional in the township, right? So I just want to make sure that I understand, and maybe the rest of us understand exactly what we're voting on. So we are voting to grant a waiver on everything except for items 23 and 26. Is that correct?
Correct.
And so item number 52, the tree plan.
Correct.
So would your recommendation at this point be that we do grant that waiver based off the conversations that we're having? And will that hinder a tree plan from being submitted when they come in front of the board for the subdivision?
So, Mr. De Palma, my fear with the tree plans is always that once it goes past the board, there have been instances where trees are removed and, we find out at a later stage. So generally.
I know. That's my biggest concern. I'm dealing with the
Exactly.
issue at this point. So
Exactly.
my concern is that you turn around and there's no trees left.
Exactly.
And I'm not saying that the applicant is looking to do that, but we've had a history of that occurring, and we're living it.
I mean, you know what? It's like it goes hand in hand. The reason I brought up the wetlands is because I want the applicant to know before he or she is far invested in this application that there are wetlands. If they're assuming they will, mow the land behind, they will clear the trees at the back and expand the backyard, then be cognizant of the fact that it is wetlands governed by DEP. You cannot really go and use that land. It is not something that can be a part of your property. I've been very vocal when it comes to odd-shaped lots such as this, when there is no true benefit. When the subdivision, the entire Jamie Court subdivision was created, there was a reason why these lots were laid in this fashion, right? So now we are changing the pattern and adding this land. And to me, something that really doesn't have as much value because it's environmentally constrained. But at the same time, I understand where Mr. Cerdello is going, that if it comes to a point during the hearing phase that we feel they have to go back to DEP, they will have to do that. Any trees that are cut or required to be cut, it's a bigger problem because now you're in the wetland area. Maybe when it rains, that area floods. I don't know. I can only superficially look at it from the GIS data, right? Usually. And in other instances, I wouldn't have said that, okay, waive the tree plan, knowing the history. But in this case, because it's wetlands, because there is DEP control over it, I'm comfortable to say, let's proceed. Let's proceed with the completeness. Let's hear the application at the complete application. And at that time, probably have that as a condition of approval, because we still have a chance. It's not like they are in front of the board today for a complete hearing. So I still think we can handle it when they come back.
Ms. Sawant, you use the word benefit, and that's kind of a question I've had too, is what is the benefit of this subdivision? What is the purpose? That's one of my questions.
That is correct. And to me, while Mr. Fraser was talking, I'm just thinking, I mean, why would you add a land that is not really usable? And, and I brought this up with the map and everything so that even the applicant hears about the constraints that are on the property and, gives it a thorough thought before they come in front of the board.
Can I say something? I really
Mr.
don't
Petty?
think too much. Yes, this is
Sure, absolutely.
I just want to say, if I was in this situation and they wanted to give me property behind my house, that I couldn't use for wetlands, why would I do it? Why?
Yeah,
I live in a development in the back of my house. There is a big open field, but I have a fence. I don't use that field. Whatever it is, it is. I like looking at it. Why would I want to take property behind my house where I'd have to pay more tax, maintain it, and couldn't do anything on it? So that's my feeling. I'm
good,
not,
yeah, good
I
point.
don't like it. I'm
Chairman Marucci, you mind if I comment on this as well?
No, go ahead, Steve.
All right, first off, this is not conducive to the actual layout of that community, which Ms. Sawant had mentioned. Being the president of my homeowners association, we had a similar circumstance like this, where the one person decided to move his entire fence onto an easement area. So let's take in fact that he moves his fences out 20 to 30 feet out to the edge of a tree line. What now happens is, let's say this gentleman decides to move his fence out to where the wetland stops, or as we had another member of our association, once the town and the development was built, he decided to clear all the easement land behind him, which nobody ever turned around and said, you cleared the easement. But what turned out to be is that when he moved his fence 20 feet out, he is now sitting 20 feet out further than the actual property lines and looking into the people's yards now. That's a circumstance, and it caused a big, big problem in our development. So I don't see this being conducive to the actual layout of this particular development. And Ms. Sawant was on target saying it's not conducive. That's why this was laid out that way.
Well, if I may just, Mr. Chairman, if I jump in, I think we're getting a little outside the scope of what we're here for this evening. We're talking now to get into the merits of the application. We haven't had any testimony on it. We haven't heard anything from the applicant. This is at this point just a completeness review as to whether or not they are deemed complete and whether we're granting the waivers for those items that they're not submitting to the board, and whether we can schedule the hearing before the board. We're get into the merits of it. I just want to be careful of that.
I understand being careful, but we have not to speak for all, but we have some confused members here going, why are we even talking about it? So if you can, relate that as to why we're talking about this, because it doesn't seem logical.
Point well taken. Okay, do we have any other questions or input from the board members or professionals?
No. So yeah, just so Vina, your recommendation to us is what?
So my recommendation would be to waive this for now, bring them to the board, because one more thing, Mr. De Palma, I'm pretty certain that when we have, in the past, when we had such situations, we have asked the owners to flag and fence the wetland area so that there is no encroachment in future, there is no usage of that space. So that I'm pretty certain we can handle it at the planning board hearing level.
Okay. Well, my biggest concern is not the future. If I could see the future, I would have won the lotto like 5 or 6 times already. So, but I just want to make sure that what we are going to waive is of the recommendation of you, and it does not affect anything when they do come in front of the board for the application. So this is really we're just waiving this for them to get to us, and then when they get to us, they're going to need to submit A through Z. Unless they come back with, instead of this, we want to waive this for that piece of it. This is just initial application to get in front of us. We'd like this waived.
That is correct. And that is why in my memo, the last line of the memo even says that granting of this waiver doesn't mean that at some point during the review process, we will not ask for more information. So the applicant has a copy of the memo, and so we are only temporarily waiving it so that it can be heard in front of the board.
These are just submission waivers. These aren't design waivers. These aren't ordinance waivers. These are just submission checklist item waivers at this point.
Yes, and if we look at it, if you can look at it from 180 degrees, it's not, don't look at it as we're just not granting 23 and 26, just that 21, 25, 37B, and 52 are being granted. Those waivers are being granted. Don't even consider the other two. Pretend they don't exist at this point. Would that be a fair summation, Mr. Sodillo?
Yeah, that's one way to looking at it, is that this is just at this point, if the board deems or grants these submission waivers, then they would be granting a waiver from items number 21, let me see, 21, 28, 37B, and 52. So those items identified there would not be submitted to the board or required to be submitted to the board for completeness purposes for the scheduling of the hearing. Doesn't mean that we might not ask questions on those informations, or that they might be an issue that comes up during the board hearing, and they may need to provide some additional information with regard to those. But just for completeness purposes, for submission purposes, those items are being waived, being required for completeness.
And speaking to Mr. De Palma's concerns, number 52, the tree plan, that is something that would be discussed and considered during the wetlands review.
Absolutely. We could still put conditions saying that no tree can be removed. If an approval is granted, we could say that if the tree is removed, it can only be pursuant to coming back before the board. All those still remain. We're not granting any approvals with regard to the trees. We're just saying they don't have to go out, survey every tree, and submit a tree plan in connection with the subdivision application.
Gotcha. Okay.
Mr. Sodillo, you should have said this about 25 minutes ago.
Sorry.
I don't know what's going on. You should have said this before.
Clarification on one. Sounds probably redundant, but can I get just clarification? Because sometimes I think in the past we've had, if they go through one procedure, and I'm not saying it's necessarily the waiver one, then they seem to think that they have permission to do a certain amount of land clearing or, preparation for whatever. This no way would allow them to do that, right? I mean,
Correct, it would not.
I think it's been done even when it's not appropriate or not.
And let me be clear, we're not asking for any of
Nothing can be
this.
done until an actual plan is submitted.
Okay, Mr. Fraser, you
All
have
right,
I just want to be clear, we're not asking for this. We're not clearing trees. We're not doing construction. We're not doing anything. We're drawing a
I
line.
know.
Okay. All right. Any other questions or comments?
I'll move it based off of what Mr. Sodillo just said.
Okay, moved by Mr. De Palma. Do I have a second?
Mr. Chairman, I have a question.
Yes, Mr. Lauer.
Mr. De Palma just said he's going to move it based on what Mr. Sodillo said. Are we still keeping 23 and 26 off?
Yes.
So
Yes.
we're voting on all the waivers except for 23 and 26.
Pretend they don't exist.
Okay, so can we state that like that?
Yes, if you'd like, Mr. Chairman, I'll state the motion. The motion has been presented by Mr. De Palma is a motion to grant the waivers for items number 21, 28, 37B, 52. All other requirements having either been already submitted or to be submitted are required.
Understood.
Okay, and the motion was put forth by Mr. De Palma. Do I have
I'll
a second?
second it. I'll second it.
By Mr. Renna. He beat you, Marty.
Okay.
Mr. De Palma,
Yes.
Mr. Renna,
Yes.
Mr. Lauer,
Yes.
Mr. Mamakis,
Yes.
Ms. Cannon,
yes.
Mr. Schmitz,
Yes.
Mr. Lenning,
Yes.
Mr. Pink,
Yes.
and Chairman Marucci.
Yes.
Thank you, Mr. Chairman. I wonder if the board might indulge a question, which is, what does that mean as to when we would be placed on the agenda?
My office, I'll answer that.
Okay.
So now that the waivers have been granted, the department will review it tomorrow morning, and we will issue a memo with a date for the public hearing, provided all other items are provided. There is no incomplete item on the memo that was issued earlier. So in short, if everything else was submitted other than these waivers, now that we have an approval from the board, you will get a hearing date from us within a day or two.
I'm assuming from what I'm hearing and from what I observed before we started this hearing that it's unlikely to be September. Is that a fair statement?
I cannot say that with certainty because if it is a minor subdivision, it may even be able to go to the committee, which meets prior to the public hearing. But I have to review the application.
Okay, very well. Mr. Chairman, I appreciate the board's and members. I appreciate the board hearing us this evening. Thank you for your consideration, and we look forward to presenting the matter in full on the merits at the appropriate time.
Thank you, Mr. Fraser.
Thank you and good night.
Good night. Okay, if that's all our business, I will put a motion out to adjourn.
Mr. Chairman, we have to, just because it's under the Public Meetings Act, just have to do a general public comment period.
Oh, even after the vote?
Yeah, well, no, just to address any issues. It won't be anything on specifically on the agenda. It could be anything, just a general public comment period. It's required under the Open Public Meetings Act.
Okay, so we'll put it out to the public for a minute.
No raised hands. I have no raised hands.
Do we see any hands up?
Nope, there are no raised hands.
No raised hands. All right, we'll give it another 15 seconds. Okay, since there are no raised hands, we will close the public portion. And if there is nothing else, I'll ask for a motion to adjourn.
I'll move it.
By Ms. Cannon, and a second?
I'll second it.
By Mr. Pink. You got that one in. You snuck that one in.
Mr. De
All
Palma?
right, everybody. I appreciate your time. Thank you very much.
Good evening.